Where one or both of the parties are not represented by lawyers, the tribunal chairman may involve themselves much more in the cross-examination than has occurred in this case.
Yes, sir, I do have just one question. Mr. Maxwell, you've been asked about whether you did or did not do certain things, such as talking to the police, having conversations with the customers and so on before you dismissed the claimant. Now, you were there at the time. You took the decision to dismiss. In your mind, did you think you'd done enough?
Yes. In the circumstances, I really think I had. I had the surveillance report, I knew about the theft, and he didn't deny a clear allegation. I honestly believed at the time that Julian was guilty. Doing any of those additional things wouldn't have changed anything.
Thank you, Mr. Maxwell. I have no further questions for this witness, sir.
Thank you, Mr. Maxwell.
Remember that once a witness has left the witness box, their evidence has finished. Only rarely will a witness be brought back to give more evidence. For instance, if it's felt necessary for that witness to address a point that arose later in the hearing. The tribunal decides this. So, Hilary, who's next?
My second witness, Margaret Bradshaw. She's the chairman of Hannigan's Brewery.
Right, Ellen, how are you going to deal with Mrs. Bradshaw?
There are two main issues with this witness. Firstly, that she made up her mind that the claimant was guilty before the appeal hearing. And secondly, that the hearing was a review rather than a rehearing, and so couldn't put right the defects in the disciplinary process. Philip Maxwell told you that Julian Kirby had been up to no good, didn't he?
He said that he'd suspended him.
And you trust Mr. Maxwell's judgment, don't you?
Of course. He's our MD.
So, if Mr. Maxwell described the tip-off and his wish to take a firm handle of the situation, you would go along with him, wouldn't you?
It depends what it was, not if I knew otherwise. I just considered the evidence, asked for some explanations from the boys and took it from there. It was fair, if that's what you're asking. I gave them plenty of time. The point is, they still didn't say they didn't do it.
Chris, a point to remember when you're questioning is that sometimes you get what you want relatively easy and quickly. If that should happen, then you should move on. At other times, you might find the witness will not give you what you want, whatever you ask them. Again, it's best to move on, otherwise you might irritate the tribunal or you might look desperate. It also can detract from the good points that you've made. The truth is that the tribunal is likely to pick up on a witness that has been deliberately awkward.
Any questions in re-examination, Miss Winston?
No, thank you, sir.
Why didn't you re-examine this witness?
You have to choose your moments with re-examination. In this case, I didn't think there was anything that particularly needed clarifying. There's no point in asking questions simply for the sake of it. In fact, with some witnesses, there's a danger that it could make matters worse.
Sir, I'd like to call my witness, the claimant, Julian Kirby.
Some tips for witnesses. Reread your witness statement before giving your evidence. Make sure that before answering, you understand the question you're being asked. If you don't, ask for it to be repeated. Think about your answer before giving it. And most importantly, tell the truth at all times.
I, Julian Kirby of 1 Acacia Avenue, Grange Hill, Reading, will say as follows. I started working for Hannigan's Brewery in 1992, originally as a relief bar person in the Fox and Rabbit in Swindon. On the 23rd of November at about 4 o'clock, George and I were finishing work when Phil Maxwell, the managing director, came to see us.
I think you boys know why we're here. We've done some digging around and have no option but to suspend you both. Freebies have been given out. That's gross misconduct, you know. Now clear your stuff and get to head office for 4 p.m. on Thursday.
I later found out that George Brown had admitted his involvement in the non-payments and had been cautioned.
Thank you, Mr. Kirby.
How are you going to deal with Mr. Kirby? He's claiming not to know what went on.
He is, but he's been inconsistent, and I hope to be able to exploit that. The main thread of my cross-examination will be to show that although the company's procedures weren't perfect, they were good enough in the circumstances. He did know what was going on, and when questions were put to him, he failed to respond to them. And therefore it was fair for the company in the circumstances to believe that his silence was indicative of his guilt. Now, Mr. Kirby, when Mr. Maxwell came to see you on the 23rd of November, he told you what the allegations were against you, didn't he?
Not really.
Well, you understood that you were in trouble because you were being suspended, weren't you?
I thought there was a problem and they needed my help to sort it out and find out what had happened.
Mr. Kirby, you had 3 good opportunities to explain yourself or ask questions. The first was at your suspension. The second was at the disciplinary hearing. And finally, you had a third opportunity at the time of your appeal. Why didn't you say anything on any of those 3 occasions?
I was confused. I didn't know what they were talking about. I didn't think they thought I'd stolen.
Come on, Mr. Kirby. If someone accuses you of something, then you wave your arms in the air and say, I didn't do it, don't you?
Usually would, but I didn't know what they were on about.
That doesn't explain your behaviour. It was a straightforward allegation of theft against you, and you didn't say a thing. Why not?
I don't know, I just didn't understand what they...
But this was a serious matter. You knew it could lead to your dismissal.
I just didn't understand what they were talking about, that's all.
And that concludes the evidence, does it not?
So yes, it does. If I could refer the tribunal to the skeleton argument and the chronology which I submitted this morning, I intend to follow those in my closing.
That's helpful. Many thanks, Ms. Pennell. Please proceed.
Once the tribunal has heard all the evidence to be put by both sides, each party is given an opportunity to summarise or close their case. We'll hear how Ellen starts her closing. Then I'll explain to you the structure of a closing speech and the sort of things the tribunal want to hear in it. When Ellen's finished her closing, we'll hear a much larger part of Hillary's so that you can see how it's done.
Sir, the claimant is a decent and honest man. He has been employed by the respondent for more than 10 years and has an exemplary record. He was not in any way, shape or form involved in this misconduct, a fact that would have been glaringly obvious to the respondent had they carried out a fair procedure. But the respondent chose not to. The respondent failed to comply with a statutory disciplinary procedure, which goes some way to explaining why Mr. Kirby had no idea what was going on.
It's rare for there to be a closing speech in a very simple case, such as a wages claim. But in more complicated cases, such as involving unfair dismissal or discrimination, a good closing speech can really help the tribunal. They should remind the tribunal of the relevant points arising from the evidence, and whilst the tribunal will have listened carefully to the evidence, closing speeches serve as a reminder of the key facts and reinforce each party's case, though it's not necessary to restate the obvious. An effective closing speech can persuade a tribunal to decide an issue in a certain way. It will relate the evidence to the legal tests the tribunal has to decide. Closing speeches should be succinct and to the point. And some chairmen will want to debate or discuss the issues with the parties, particularly to ensure that the tribunal understands the case of unrepresented parties.
My primary concern is actually to make reference to documents as opposed to what witnesses may or may not have said.
What the tribunal doesn't want to hear is a rambling, potted version of all the evidence that they've just spent a day hearing. What they do want is a focused, punchy closing where it's clear that the parties have identified what the issues are.
I think it's unwise to aim your submissions just at the chair because that will exclude the wing members. You certainly bring along copies of submissions for all of them. You address all of them when you're making your submissions, and you try to include them all.
These are great tips. Sometimes people in tribunal will refer to previous cases to support their argument. Watch how Ellen does this.
I would like to refer the Tribunal to the current guidelines set out in the case of Linfood Cash and Carry against Thompson. The respondent should have at least produced a witness statement from the informant, blanking out clues as to his or her identity. Furthermore, the respondent should have taken steps to verify the informant's evidence. The respondent did neither of these basic things. Given the grave failings of the respondent in dealing with the claimant in this case, then I respectfully foresee that no other conclusion that the claimant was unfairly dismissed, and would urge the Tribunal to make that finding.
Thank you, Ms. Purnell. Ms. Winston.
Sir, we mustn't lose sight of the fact that this is the case of a theft from an employer, a case involving a very serious breach of trust. Here we have a respondent that had incontrovertible evidence via independent surveillance that a theft had taken place. There are three questions to consider. Firstly, did the employer honestly believe that the employee was guilty of misconduct? Well, this hasn't even been challenged in this case. Secondly, did the employer have reasonable grounds for that belief? Well, we say yes. The evidence before it pointed to this. The combination of the tip-off, the surveillance report, and the claimant's silence was damning. I'm sure I needn't remind the Tribunal that the employer's decision to dismiss must be considered in the context of what the employer knew at the time, and not what has subsequently emerged. Now, the third question is whether at the time the employer formed its belief that the claimant was guilty, the employer had carried out such investigation and followed such procedure as was appropriate to the circumstances. The respondent contends that it did carry out a reasonable investigation into the claimant's misconduct. The respondent put the allegation to him orally and in writing. It commissioned an independent surveillance. It held a disciplinary hearing at which the claimant was told he had the right to be accompanied. The claimant didn't deny the allegation. The respondent was at that stage, therefore, entitled to crystallise its viewpoint such that the obligation to investigate further was at an end. The decision to dismiss was the decision of a reasonable employer. Thank you, sir. Those are my submissions, unless you have anything else that you would like me to address you on.
Thank you, Ms. Winston.
Chairmen often take the opportunity during closing speeches to test each party's case. The chairman may stop an advocate at various points during their closing speech to discuss or debate the submissions that have been made. This is common.
Thank you for those helpful submissions. I propose that we adjourn now. Our clerk will let you know when we have reached our decision.
The panel will now discuss the case to reach its decision. This can either be unanimous or by a majority. The Tribunal will try to give its judgment at the hearing, together with the reasons for it. The parties will then be sent a brief written judgment, which just sets out the conclusion. Either party can ask the Tribunal to give its full reasons in writing if it thinks further clarification is required, or if it wants to appeal. In some cases, the chairman will adjourn the hearing and give its judgment at a later date. In this event, the Tribunal will provide in writing full reasons for its judgment. It aims to do this within 28 days. Now, for the purpose of this DVD, we're not going to second guess what the Tribunal would have decided, because you've only seen a portion of the evidence. Instead, let's talk with Janet Gamer, who, amongst other things, led the task force that reviewed the tribunal system, and we can gauge her perspective.
I think if you have a dispute relating to your employment, the first place to resolve it is actually in the workplace, at work. Because if you don't resolve it there, it's much, much more difficult to do it when you've left employment. And there will often be procedures that your employer has set out in order to help you to do that. So you need to follow them. I think if you're going to try and resolve a dispute, you have to work at it. It's like anything else in life. You have to keep trying. You may not have been able to do it in your workplace. Now, there are other ways of doing it. One way, of course, is to bring a claim in the Employment Tribunal. If you're going to bring a claim in the Employment Tribunal, it's very important to inform yourself about the nature of your claim, whether the tribunal has the ability to hear it, and what you will receive at the end of the day. Because going to an employment tribunal should not be undertaken lightly. It is a process which requires concentration and may take some time. Not always, but it may take some time. And while you're doing that, you may be deflected from, for example, looking for another job. So I think you have to be comfortable yourself that you're doing the right thing. When a claim is commenced in an employment tribunal, the emphasis now is very much on ensuring that the issues are established at an early stage. There are a number of ways in which that is done. In particular, the tribunal will take an active approach to what is called case management. It will work very, very hard to ensure that each party understands precisely what the other side is saying.
And what role does ACAS play in this process?
ACAS is there as always a source of advice and, more importantly, assistance in relation to settlement of the dispute. There are particular stages in the process where ACAS is able to intervene, but actually when you look at it at the end of the day, the whole process of resolution of the dispute is down to the parties all the way through the process. And in my view, they should be trying to resolve the dispute right up until the last moment of the hearing. ACAS is very useful as a bridge, a bridging mechanism between the parties, particularly an independent bridging mechanism, and that is often very, very helpful in resolving disputes. If the parties are both legally represented, then the solicitors will often talk to one another on a continuous basis throughout a tribunal claim. It is important that there is an open exchange if you're going to have a discussion about settlement. Having said that, when I say open exchange, there are legal techniques in order to ensure that the exchange may be as frank as possible. One way of doing that is to agree that the discussions are so-called without prejudice, and that enables the parties to speak frankly about the issues and perhaps to say things that they might not otherwise want to say in open correspondence.
And of course, all conversations conducted through ACAS or with their assistants are also without prejudice.
Indeed, all conversations with ACAS are conducted on a confidential basis and will not be referred to in the tribunal proceedings. It's a fundamental tenet of the way that ACAS operates.
One of the techniques used by some lawyers is to make a without prejudice offer to their opponent, but to back it up with a threat of what will happen if the party doesn't take it. Do you think that tactic works?
I believe in an open exchange of views in order to resolve disputes, and I don't think threats from one side to another necessarily help. They may also be illegal in the wrong set of circumstances, particularly if one party, for example, is threatening to go for an award of costs against the other party. There is a view that that might amount to victimisation, for example, in a discrimination claim. So I think one needs to be very, very careful about that. The important thing to remember is that the rules which govern employment tribunals require the parties to cooperate. They should cooperate in order to bring the claim to a satisfactory conclusion.
And it is important, isn't it, that at all times, even up to the hearing, that both sides understand the value of the claim that's being brought?
Often people go to tribunals for all sorts of different reasons. You will often hear parties saying, I'm fighting this as a matter of principle. Now, principles can sometimes be very expensive, and I think it is important that a party who is going to an employment tribunal sits down and really says to himself or herself, why am I doing this? What is the remedy at the end of the day? And if I go through this whole process, is that what I really want? Now, maybe that is what they really want, but I think it is important that they obtain the advice and information at an early stage in order to establish that. And if there is a specific loss that they wish to tell the other side about, they should tell the other side.
Do you have any sort of broad overarching tips for them about how they should conduct themselves?
So far as actually operating in the tribunal, I think going back to the very beginning, it is important, if you think you are going to be bringing a claim in the employment tribunal, to record the basic facts about your claim at a very early stage. Time is a thief of memory, and after some weeks or even months, you may not be able to remember precisely the details of what it is you're complaining about. So first of all, get it down at an early stage. The second thing is, when you arrive in the tribunal, it's important to listen, and also, if you can, to have familiarised yourself with how an employment tribunal works. Now, one way of doing this is, before your claim is heard, to go along to your local employment tribunal. The hearings are usually in public. It's very rare for them to exclude the public, and you can sit at the back of an employment tribunal claim and just see how the proceedings are conducted. And that is, in my experience, very useful if you are going to be attending yourself, particularly if, as is usually the case, you will be giving evidence. When you eventually sit in the witness, well, it's not a box actually, it's a simple table and chair. Again, you will need to listen to what the chair says to you. You will need to listen to the question which is put to you. And I know this sounds very simple, but some people find it difficult. You will need to answer the question put to you. It's very tempting to say other things. You need to listen.
Don't ask questions back.
And also, don't ask questions back.
A large number of parties who appear in the employment tribunals are unrepresented. Do you think that they find themselves at a material disadvantage by being unrepresented?
I think if you're unrepresented in an employment tribunal, particularly if the employer has one or more legal representatives with him or her, you can feel very daunted. I think the thing you have to bear in mind is that the chair is there to ensure that there is equality of arms, as we call it, between the parties. The chair will try to ensure that you not only understand what is happening, but give you every opportunity to respond to the points that are put to you. So to that extent, the chair is your friend. The chair will endeavour to get the issues out and to ensure that each party feels that he or she has been heard properly.